It is not dependent upon getting a share from the father. He does not get a share from the father. If the father has owns the property as co-partnership property, as soon as a son is born, he acquires a half right in the share of the father. So therefore, he gets a right by birth. So and if it is the self-acquired property of the father, let us think. I told you about the co-partnership property. If the property is the self-acquired property of the father, then the sons do not get any right during the lifetime of the father. If it is co-partnership property, the sons get a right by birth. So therefore, this principle should be clearly in mind. This is what is called, there are two principles, obstructed heritage and unobstructed heritage. Pratibandha daya, it's called as Pratibandha daya and Apratibandha daya. So Pratibandha daya is, see, as you get a share in the properties only on the death of somebody else. So therefore, you don't have a right in the father's self-acquired property during the lifetime of the father. It is only on the death of the father the son gets a right in the self-acquired property of the father. That is, the succession is dependent upon the death of the father. This is called Pratibandha daya. So there is an obstruction for succession. Whereas in co-partnership property, the father's property would devolve upon as soon as he is born, he takes a share in the family properties. So therefore, the concept of Pratibandha daya and Apratibandha daya, that is obstructed heritage and unobstructed heritage, should be clearly in the mind. So therefore, see, then after 1956, there was a change in the law. A further change was made when the Karnataka Amendment was brought into effect. And a further change was brought about by Act 39 of 2005 in the year 2005. Now I will first deal with what was the law prior to 1933. The law prior to 1933 is what I would, though it may not be very relevant for the present, I would only, as a preface to my lecture, I will say a few words about the law that was in force prior to 1933. There are primarily two schools of Hindu law. The Dayabhaga school and the other is what is prevalent in Bengal, that is the Mitakshara school and the Dayabhaga school. The Dayabhaga school is prevalent only in Bengal, whereas the Mitakshara school is prevalent in all the other states. Even under Mitakshara school, there are four schools of Hindu law. One is Banaras school, the second is Mithila school, the third is the Maharashtra or Bombay school, and the fourth is the Dravida school or the Madras school of Madras school. In fact, all these schools, they follow particular Sanskrit texts as source of law. You will find that the Banaras schools usually depends upon Veera Mitrodaya and Nirnaya Sindhu. These are the two Sanskrit texts on which the Banaras school is dependent upon. As far as the Mithila school is concerned, there are four textbooks on which they rely upon. That is Vivada Chintamani, Vivada Ratnakara, Madana Parijata, and Vyavahara Mayuka. These are the four texts on which they rely upon. The Maharashtra or the Bombay school, they rely upon Veera Mitrodaya Nirnaya Sindhu. Whereas the Dravida school or the Madras school, they follow Smruti Chandrika, Parashara Madhaviya, Saraswati Vilasa and Vyavahara Nirnaya. Mitakshara is actually a running code scribed by Yagnavalkya. And for this running code of Yagnavalkya, and this was then in about the 12th century, Vignaneshwara, he wrote the law pertaining to Mitakshara on this code. So therefore, this Vignaneshwara's commentary on Mitakshara is being followed. And as far as Dayabaga school is concerned, the Dayabaga school is, they follow the commentaries of Jimutavahan. And the basic difference between Mitakshara and Dayabaga is this. In Dayabaga school, they don't have the concept of right by birth. They don't have the concept of a co-personally in Dayabaga. And there is no question of survivorship. As long a person is alive, he holds the property. So all succession is apratibandha daya. It is obstructed heritage only. There is no right by birth at all as far as Dayabaga school is concerned. Then as far as Mitakshara school is concerned, the concept is different. They have the concept of a joint family property, separate property, and the daughters, they don't acquire a right by birth. The sons only acquire a right by birth, and all the concept of survivorship. All these things are available in Mitakshara, and under the old law, there were three categories of heirs who were entitled to succeed. They were Sapindas, Samanodakas, and Bandhus. So in the first, see that according, I will only be concentrating on Mitakshara, because in Mitakshara there were three classes of heirs. One is Sapindas, the other is Samanodakas, the third is Bandhus. The Sapindas, they constituted 6 degrees from the male from whom we are trying to find out the succession. So that is father, father's father, his father, his father, his father. So 6 generations upwards, and son, grandson, great grandson, etc., etc. 6 generations down. So these people, and brother, brother's son, his son, his son, his son, 6 generations. So therefore, 6 generations upwards, 6 generations downwards, 6 generations on the collateral line, and all connected by the male line only. So if all these people put together, they would constitute Sapindas. They are called Sapindas. Then the Samanodakas are after the 6th line, from the 6th generation to the 13th generation upwards, from the 6th generations to 13th generation downwards. Then on the collateral line, from the 7th generation to 13th generation, on the collateral line, they would constitute Samanodakas. The other relatives are called Bandhus only. In fact, in order to correctly understand this genealogy, I am only giving you a bird's eye view of this. I am not going to the details of all these relationships. See, if you want to understand this correctly, you can go to Mulla's Hindu Law, that is the 25th edition at page 125. He has given a genealogy of all this, and he has explained who are Sapindas, who are Samanodakas, and who are Bandhus. And even amongst Sapindas, there are two varieties. That is Gotraja Sapindas and Binna Gotraja Sapindas. There are two varieties of even among Sapindas. In fact, Gotraja Sapindas are those persons who are related to the deceased in an unbroken male line. If there is a female intervenes in this line, then they will be called Binna Gotraja Sapindas. So therefore, the preference would be and always nearer in degree, exclude the more remote, as far as succession is concerned. If a son is there, the grandson will not get. If a son is dead, then property goes to the grandson. If both son and grandson are dead, the property goes to the next generation. So therefore, the nearer in degree exclude the more remote. That's one thing. Number two is the law to be applied always is succession is never in vacuum. You should always keep this in mind. When a person dies, what is the law in force on the date of death? It applies. And the property vests in the heirs immediately after the death of that person by succession or whatever mode it is. And when once the property vests in the heirs, it will never get divested. So this principle of Hindu law has been there from very early times, and that's also being followed even now. Now, there are actually 57 classes of relationship. If you go to that chart in Hindu law Mullah, there are 57 relationships who are classed as Sapindas, and there are 142 relationships which are classed as Samanodakas. Now we will. I have told you about the concept of a co-partner and a joint family. Females, unmarried daughters in the family, wives of co-partners, they are all members of a joint family, but they are not members of a co-partner, and they don't get any right on succession in the family of a male after his death. It is only the males who are entitled to succeed under the old law. Then the first legislation that came into force was in the year 1933. In the year 1933, a law, Hindu Mysore Law, Women's Rights Act 1933 was brought into force. In fact, there was always a concept of Stridhana under the old law. Stridhana meant primarily the property acquired by a female with her own money or property gifted to her, they would constitute Stridhana. And succession to Stridhana was controlled by different set of rules under the old law. Then for the first time, this Mysore Law, Women's Rights Act 1933, this came into force in the year 1933, and section 4 lists the heirs who would succeed to a property, a female. Section 4 clause A says, where a male Hindu dies, the property goes to his son, grandson and great grandson. So therefore, the property would not be, no succession. A daughter would never get a right in the property of the father if a son, grandson and great grandson is alive. So if all the three persons are not alive, if say that the male has no sons, then the property would devolve upon the widow, his widow. Then if the widow is also not there, no males, no son, no grandson or no great grandson, but the widow is also dead, in such situations, the property would devolve upon the daughter. So therefore, for the first time, a right by succession to a female was recognized in the princely state of Mysore in the year 1933. This act is applicable only to the princely state of Mysore, and this was made the law in the year 1933. Then, and there was also one other provision that was made in section 8. Section 8 said, the earlier law was, at a partition, males alone would be entitled to a share. A new concept was introduced under section 8 of the Mysore Act, wherein they said, at a partition, a widow, unmarried daughter, and a few other persons were given a small share in the property at a partition. Then, suppose there is a sole surviving co-partner. There are no other male members except the one male member. When the property passes to a sole surviving co-partner, the unmarried daughters, the widows in the family, they were also given a right to share in the co-partnership properties. That is section 8. And one more important thing is that under this law, a widow or an unmarried daughter or the other persons who are given a right, they could not file a suit for partition. If the male members divided the properties amongst themselves by way of partition, then only the female member, the widow or the unmarried daughters would be entitled to a share according to law. If the male members did not want the properties to be divided, the female could not claim a right of partition, and she could not file a suit. So therefore, her right was restricted only to a situation where the male members had a partition of the family properties, and not to a situation where there was no partition in the family properties. So therefore, the right to which, the restricted right to which a female was entitled to was available only at a partition and not otherwise. And one other thing was, whatever share the female got, the female would not acquire an absolute right in these properties. The female would get what is called a women's estate. She could only enjoy the properties during her lifetime, and after her lifetime, the property would revert to the father or other person, and the succession would take place as if the father had died on that day. So therefore, she could not give this property. She could only alienate the properties under limited circumstances. That's all what he could do. She had only a right to enjoy these properties during her lifetime. Then under section 12 of this act, you will find for the first time what is Stridhana properties is also defined. What is Stridhana properties and how succession to Stridhana properties should take place. So as far as Stridhana properties were concerned, both the sons and daughters would be entitled to a share in the Sridhana properties. So therefore, for the first time, a daughter would inherit the Sridhana properties of the mother under section 12 of the Hindu succession of this Mysore Act. Then, as I've already said, all females got only a limited estate and they did not get an absolute estate. In fact, I would draw your honor's attention. I'm sorry, I thought I was in a court. I would like to draw your attention to two decisions of the Karnataka High Court relating to this 1933 Act. The first is 1987, to Karnataka Law Journal, page 375, Annamma versus Pattamma. So this decision very clearly said that this 1933 Act is applicable in respect of the princely state of Mysore. So this Act was applicable only to the princely state of Mysore and to no other area. There was one other Act which was brought into existence for the remainder of India, and that was called the Hindu Women's Right to Property Act 1937. And this did not bring about any wide ramifications. Only two changes were made in the law that was in force earlier. The first change is that in respect of self-acquired properties of a male, a widow would be entitled to the same share as a son. So earlier, a widow would not get a right on succession, but she would get the same share as a son under the 1937 Act. Then, it also said a predeceased son's widow inherits in a like manner as a son. And if there is no son surviving of such predeceased son, then in a like manner, the son's son, if he is surviving a son or a son's son, such predeceased son. So therefore, the widow of a son, the widow of a predeceased son of a predeceased son, the widow of a predeceased son of a predeceased son of a predeceased son, they would also be entitled to a share in the self-acquired properties of a male. Then, if there is a partition of the joint family properties, in such a situation, the widow would take place of her husband. So she would get, earlier, she would not get a share at all. But like a son, a widow would also get a share in the co-partnership properties, his share of the co-partnership property of the husband also. So that was the one change which was brought about by the 1937 Act. Then there was a very wide change brought about in the year 1956. On 17/6/1956, Hindu Succession Act 1956 was brought into force. This brought about wide ramifications and it gave an absolute estate to the daughter and to the widow who acquired some property from her husband. Now you have a tester. Tester here.
ಶೇಕ್ ಆಗ್ತಾನೆ. ಓಕೆ, ದಟ್ ಈಸ್ ಶೇಕಿಂಗ್.
Sir, you can keep that mic in your pocket.
Huh?
Pocket.
All right, that will be fine. This father has, say, two sons, S1, S2 and S3. And the wife is there. Let us say the mother is also alive. Then, as far as the father's self-acquired property is concerned, there is no difficulty. All persons who are mentioned in clause 1 of the schedule, they would inherit the properties of the father. So therefore, as far as self-acquired properties of the father are concerned, the son, another son, this son and the daughter, the widow and the mother, all these persons will be sharers. So therefore, 1, 2, 3, 4, 5, 6 sharers. So therefore, the mother also get a 1/6 share, the wife also gets a 1/6 share. All these children will get a 1/6 share each. 1/6 share each. There was no, as far as the self-acquired property was concerned. Suppose the father wanted to deprive the mother, the widow or the daughter or the sons of a share, he could execute a will in respect of his properties. So the father had a right to execute a will and deprive all these persons of a share in these properties, if they are self-acquired properties. So he could say, he could even give by way of a gift or by a will to a stranger, ignoring all his near relatives. So all these people could be deprived of their share in the joint family property, in the self-acquired properties of the father. So let us suppose that the father had only co-pastory properties. What are co-pastory properties? I will come a little later. I will just explain which would constitute co-pastory properties. So if the father had co-pastory properties, then what section 6 of the 1956 Act said is that you imagine a partition, a notional partition should be imagined immediately prior to the death of the father. So if the father had, if there was a partition just before the death of the father, then what would happen is the father would be entitled to a 1/4 share, the sons would be entitled, this son will be entitled to a 1/4 share, this son will be entitled to a 1/4 share, and this son also will be entitled to a 1/4 share. Then as far as this 1/4 share of the father is concerned, that would go by succession. So therefore, this father's 1/4 share will be shared by S1, S2, S3 and the daughter, the wife and the mother. They are all class 1 years. So therefore, this 1/4 share of the father will be divided into 6 shares. So therefore, this 1/4 share of the father, so therefore, 1/6, that is, this 1/4 share divided by 6 is 1/24. So therefore, the mother gets a 1/24 share, the wife gets a 1/24 share, the son gets a 1/14 plus 1/24. So therefore, the son gets 1/4 plus 1/24 is 7/24. So therefore, the sons get a 7/24 share each, whereas the daughters, the widow and the mother, they get only 1/24 share. And apart from that, the father, if the father wanted to deprive his daughter, his mother and wife also as their share, the father could execute a will in respect of these 1/4 share. if the father executes a will in respect of this 1/4 share, the mother gets nothing, the wife gets nothing, the daughter also gets nothing. If he says he could give this 1/4 share to a stranger, he could give this 1/4 share to his sons, he could give it. But as far as this 1/4 share of the son is concerned, which the sons acquire by birth, the father cannot deprive the sons of this 1/4 share. The father can only deprive the sons of whatever share they acquired in the share which he had at the time of death in the joint family properties. Therefore, the only change brought about was the daughter would get a right by succession in the property of the father, provided the father had not made a will. And the share that a daughter would get would be substantially less than what a son would get in the joint family properties. This is the change that was brought about in the year 1956. Then for the first time, the Karnataka amendment was introduced to section 6 of the Act. This is how the section 6 practically reads of the Karnataka Act. I would only make a reference to that particular section in the Karnataka amendment. This is how section 6 clause A reads. In a joint family governed by Vitakshara law, a daughter of a co-partner, mark these words. Earlier it was only a son. The daughter of a co-partner shall, by birth, become a co-partner in her own right in the same manner as a son and have the same rights in the co-partnership property as she would have had if she had been a son, inclusive of the right to claim survivorship, shall be subject to the same liabilities and disabilities in respect thereof as those of a son. Then there was a section 6b is introduced. Then at a partition in such joint family property, the co-partnership property shall be so divided as to allot to a daughter the same share allotable to a son. So therefore the daughter gets the same rights as that of a son. Then section 6a subclause D, this is what is important. Nothing in clause B shall apply to a daughter married prior to or to a partition which has been effected before the commencement of the Hindu Succession Act, that is the Karnataka Amendment Act of 1990. So therefore, this act was came into force on 30/7/1994. So therefore, it said that it will, and the subsection said that it would not apply to a daughter who was born prior to 30/7/1994. So therefore, only unmarried daughters born or daughters born up to 30/7/1994, they were entitled to a share like a son in joint family properties. This applied to Karnataka only. This amendment received the assent of the President also. So therefore, and one more thing was, this amendment would not apply if a partition had already taken place prior to 30/7/1994. So if a partition had already, if the sons had already partitioned the properties before 30/7/1994, this amendment would not apply. So therefore, the amendment primarily applied to only one class of daughters, that is, who remain unmarried,
Unmarried.
after 37/1994. Therefore, this and it would not apply if a partition had already taken place on 37/1994. In fact, a similar amendment was brought about in Andhra Pradesh also with certain little variations also. Then the next Hindu Succession Act 1956 was again amended in the year 2005. This amendment came into force in 2005, and it is Act 39/2005. In fact, this provision has been subject to lot of divergent interpretations by various high courts, and this was ultimately decided by the Supreme Court in Vinita Sharma's case. Now, there is one decision of the Supreme Court which should be clearly in your mind. As I have already said, that in the 1956 Hindu Succession Act 1956, it imagined a partition on the date of the death of the father who had a share in the joint family properties. So a notional partition was assumed. In fact, what is this concept of notional partition? How this notional partition has got to be viewed is clearly explained in a decision reported in AIR 1978 Supreme Court 1239 Gurupadappa Kandappa Magadam versus Hirabai Kandappa Magadam. This is what the Supreme Court says. The explanation 1 to section 6 of the Hindu Succession Act resorts to the simple, expedient, undoubtedly fictional, that the interest of the Hindu Mitakshara co-partner shall be deemed to be the share in the property that would have been allotted to him if a partition of the property had taken place immediately before his death. What is therefore required to be assumed is that a partition had in fact taken place. What the Supreme Court says, that the partition had in fact taken place between the deceased and his co-partners immediately before his death. That assumption, once made, is irrevocable. In other words, the assumption having been made once for the purpose of ascertaining the share of a deceased in the co-partnership property, one cannot go back on the assumption and ascertain the share of the heirs without reference to it. The assumption which the statute requires to be made that a partition had in fact taken place must permeate the entire process of ascertainment of the ultimate share of the heirs through all its stages. So therefore, the concept of notional partition as explained by the Supreme Court in this decision will have got to be clearly kept in mind. Then there was, after the 2005 amendment was made to the section 6 of the Hindu Succession Act, there was some doubt as to whether the Karnataka amendment automatically got repealed or whether it is still valid, whether rights could be enforced under that act. In fact, that decision of that question is answered by a decision of the Karnataka High Court, bench decision of the Karnataka High Court in RFA 916/2014 disposed of on 15/5/2020, that is Padmavati versus Jayamadaras. So that the court has said that this amendment is not repealed by the Karnataka amendment, and therefore, if a daughter remains unmarried from between 37/1994 and 9/9/2005, then the Karnataka amendment would be applicable. Or she can take, if her rights have fructified under the 2005 amendment, then also she can take shelter and ask for a partition under the new enactment. That's what this court has said. Then the central amendment came into force on 9/9/2005. This date will have got to be clearly kept in mind. See, whenever you want to find out the rights of the parties, the most important thing is you should ascertain the correct date of death of that person. The law in force on the date of death of that person would apply to his properties, which is either succession or otherwise. So therefore, what was the law in force on that day? That's the most important question that we have got to keep in mind. Then we may go to the section 6 of the Hindu Succession Act, which came into force on 9/9/2005 by repealing the earlier enactment. We can have a look at this section because this section has very wide ramifications. That is, on and from the commencement of the Hindu Succession Amendment Act 2005, in a joint Hindu family governed by Mitakshara law, the daughter of a co-partner, earlier the rule was only in respect of a male, the daughter of a co-partner shall by birth become a co-partner in her own right in the same manner as a son. So therefore, the daughter is also given the same status as a son. That's the first section. This is subsection B. Have the same rights in the co-partner property as she would have had if she had been a son. 3. Be subject to the same liabilities in respect of the said co-partner property as that of a son, and any reference to a Hindu Mitakshara co-partner shall be deemed to include a reference to a daughter of a co-partner. Then, any property to which a Hindu becomes entitled by virtue of subsection 1 shall be held by her with the instance of co-partner ownership and shall be regarded, notwithstanding anything contained in this act or in any other law for the time being in force, as property capable of being disposed by her by testamentary succession. Then again the concept of notional partition is introduced. When a Hindu dies after the commencement of the Hindu Succession Amendment Act 2005, his interest in the property of a joint Hindu family governed by Mitakshara law shall devolve by testamentary or interstate succession as the case may be under this act, and not by survivorship, and the co-partnership shall be deemed to have been divided as if a partition had taken place, and a daughter is allotted the same share as a son. So therefore, here also there is a concept of notional partition under this amendment also. I will just explain as to what would be the concept of notional partition after 2005. Let us suppose the father has a right in co-partnership property. After 9/9/2005, the father dies. And in the act, what the section says is that the daughter is also a co-partner. Earlier she was not a co-partner. Therefore, what happens is there are three children. S1, S2 and S3. All three are co-partners with the father. So therefore, at the time of his death, the father has a 1/4 share, this son has a 1/4 share, this son also has a 1/4 share, the daughter also gets a 1/4 share. So, the father cannot deprive the daughter of this 1/4 share also. Earlier, the father could not deprive of the son of this 1/4 share because they would get a right by birth. Now after 2009, in a co-partnership property, the daughter also gets a right by birth. So therefore, what would happen is the 1/4 share of the father. This 1/4 share of the father is again shared between the wife and the three children. So 1/4 of 1/4 is 1/16. The son gets a 1/4 plus 1/16. The son gets a 1/4 plus 1/16. The daughter also gets a 1/4 plus 1/15. The wife gets only a 1/16 share. And the father has a right to make a will in respect of his undivided 1/4 share. In fact, if the father makes a will in respect of his 1/4 share, he can deprive all these persons with this 1/16 share, and he can give his 1/4 share to anybody he wants. He can give it his 1/4 share to S1 only, S2 only, both these things together, and she can or to the daughter. So therefore, the father's 1/4 share at the time of his death could be disposed of either by a will or a gift prior to his death or whatever it is. But he cannot deprive his daughter of the daughter getting a 1/4 share by birth. So therefore, the only change brought about by this amendment is that the daughter is given a right by birth in the co-partnership properties, and this right of the daughter, she gets it by unobstructed heritage. Not because the father is dead, but because by her birth she gets a right in these properties. So therefore, this is one change which is brought about by the amendment. In fact, there is lot of discussion to find out whether this amendment is prospective or retrospective. So, a lot of discussion is made, and there is the Karnataka High Court took a particular view, the Bombay High Court took a different view, the Supreme Court in 3 decisions took a different view. Now the Supreme Court, the law is set by the Supreme Court in Vinita Sharma's case, and I will come to it a little later about this Vinita Sharma's case. Now, see, we have tried to understand what is a co-partnership, who are the co-partners, who gets a right by birth, whose share can be taken away, and all that. And one more thing which should be clearly in our mind is, prior to 1956, a co-partner could not make a will in respect of his undivided share in joint family properties. It is only after 1956 a provision is made in section 30 of the Hindu Succession Act wherein a co-partner can make a will of his undivided share in joint family properties. That change after 1956 will have got to be clearly kept in mind. The earlier law was a co-partner could never make a will at all prior to 1956. Now, there is one concept of trying. See, you may understand the co-partner. You will have to find out on what property the co-partners get a right. See, there must be a subject property in which they should get a right. What would constitute a co-partner property or joint family property is a subject of very wide discussion, and a number of decisions have come which say that this property will not be co-partner property, that property will not be co-partner property, and all that. I will try to explain in a nutshell which property would be joint family property or co-partner property after the 1956 Act. Now,
Abhishek, help the sir. Rub the board. Slow.
the old law was that whatever property is acquired from the father, grandfather, or great-grandfather would be joint family or co-partner property. That was the law prior to 1956. Post 1956, that law has undergone a change. In fact, by application of section 6, this is what the Supreme Court has said. So therefore, let us say that the father has acquired properties which is self-earning. So this is the self-acquired property of the father. The father is self-acquired property. The father dies after the 1956 Act. Let us suppose he has two sons, S1 and S2. So therefore, the father's property under the new, let us say even the D1, the father's property would devolve upon these three persons in equal shares, or say even wife is also there. So therefore, the wife gets a 1/4 share, S1 gets a 1/4 share, S2 gets a 1/4 share, and D1 also gets a 1/4 share. So we will have to find out. See, under the old law, this property which a son acquired on succession to the father would be joint family property because it is acquired by his father. So whatever property is acquired from father, grandfather, or great-grandfather would be co-partner property. So under the old law, what would happen is this would be joint family property, and if he gets a son, SS1, then his share would be reduced to 1/8, and the grandson also would get a 1/8 share. This was the law prior to 1956. Subsequent to 1956, by interpretation of section 9, the court has said where a father dies, leaving behind self-acquired property, the son would acquire the property of the father on succession under section 8, and this property would be self-acquired property in the hands of the son. So therefore, under the old law, this would be joint family property. So by interpreting section 8, the Supreme Court has now said that where a son acquires the self-acquired property of the grandfather, of his father, under section 8 of the Act, because section 8 applies because it is the self-acquired property of the father, and therefore this property will be self-acquired property in the hands of the son. So if this is self-acquired property in the hands of the son, the grandson does not get any right by birth. So only on the death of the father he gets a right, not by virtue of section 6. This change is made by interpreting section 8 of the Hindu Succession Act. In fact, there are a large number of decisions on this question. In fact, the first decision on this question is a decision reported in EIR 1986 Supreme Court, page 1753. Kapoor and others versus Chandrasen.
Kapoor and others.
I will read a portion of what the Supreme Court has said in this particular case. That under Hindu law, in fact they were referring to Hindu law prior to 1956, that under Hindu law, the moment a son is born, he gets a share in his father's property and becomes part of the coparcenary. That's under the old law, part of the coparcenary. His right accrues to him not on the death of the father or inheritance from the father, but with the very fact of his birth. Normally, therefore, when the father gets a property from whatever source, from the grandfather or from any other source, be it separate property or not, his son should have a share in that, and it will become part of the joint family of his son and the grandson and other members who form the joint family with him. This court observed that this position, this is what's important, this court observed that this position has been affected by section 8 of the Hindu Succession Act 1956, and therefore after the act, when the son inherited the property in the situation contemplated under section 8, when the son inherits in a situation contemplated under section 8, he does not take it as karta of his own undivided family, but takes it in his individual capacity. As stated above, after coming into force of the Hindu Succession Act 1956, this is the law, after the 56 Act, self-acquired or separate property of a male Hindu on his dying intestate devolves on his heirs in their individual capacity. This is what's important. Devolves on his heirs in their individual capacity and not as coparcenary property. And in such a case, their children will not acquire any right by birth in such property. So therefore, this one, in fact, this law is followed in a large number of decisions. You can just make a note of these decisions of the Supreme Court and the Karnataka High Court. The next decision for the same proposition is EIR 1987 Supreme Court 558 Yudhishthir versus Ashok Kumar. And I will only read one sentence. In the last sentence, to a similar effect is the observation of the learned author of Main's Hindu Law 12th edition, page 919. In that view of the matter, it would be difficult to hold that property which devolves on a Hindu under section 8 of the Hindu Succession Act would be HUF in his hands vis-a-vis his sons. If that be the position, then the property which devolved upon the father of the respondent in the instant case on the demise of his grandfather would not be said to be HUF property. Then A similar decision, that is the EIR 2008 Supreme Court 1409, Pawar Singh versus Puran. Then the latest decision is 2019 SAR Civic page 809. That is Ashrur Singh versus Harpal Kaur. In fact, they say after the Hindu Succession Act 1956 came into force, this position has undergone a change post 1956. If a person inherits self-acquired property of his paternal ancestors, this is what's important. Self-acquired property of his paternal ancestors, the said property becomes his self-acquired property and does not remain co-partnership property. So therefore, this one class of properties, which were earlier co-partnership properties, has now, by operation of Section 8, has become self-acquired property in the hands of the son. Subsequently, if the father dies, it goes to the grandson, it will be self-acquired property in the hands of the grandson, and successively it goes on as self-acquired property only. So therefore, this co-partnership property, when once converted into self-acquired property, it would never again become co-partnership property at any time. So therefore, one class of properties is completely taken away by from the label co-partnership properties. So therefore, this in fact a large number of properties therefore would not be co-partnership properties at all if this by application of this rule as laid down by the Supreme Court. In fact, there are a number of decisions the Karnataka High Court also. I may make reference to two division bench decisions by Karnataka High Court in this regard. That is 2015, 1 Karnataka Law Journal, page 65, Radha versus Venkatappa. Then another decision in 2016, 5 KCCR, page 1273, that is Shakuntala versus Basuraj. So therefore, and there is one decision of the Supreme Court. There is one more thing. Section 19 of the Hindu Succession Act must always be kept in mind. In fact, it's better I make a reference to the
Hindu
wording
Succession Act.
of Section 19 of the Hindu Succession Act. This is how it reads. Mode of succession of 2 or more years. This applies to Section 6, Section 8, Section 15 and all those sections. It says, if 2 or more years succeed together to the property of an intestate, they shall take the property, save otherwise expressly provided in this Act, per capita and not per strips, save otherwise expressly provided. Then they take the property as tenants in common and not as joint tenants. So these two things will have got to be kept in mind. What is per capita and what is per strips? See that in fact in the same illustration I would say if we will say generally what happens is, if the father owns co-partnership property and the S1 has say he has 3 sons, S1, S2, SS1, this is SS1, SS2 and SS3, let's say. Another son, S2, has another two grandsons, SS4. Only one son, let's suppose he has only one son. See, the father's property should be shared by all these persons. See, if the father dies, having co-personal property, then this son, the father gets at the time of his death a 1/3 share. This son also gets a 1/3 share, and this son also gets a 1/3 share. And in the 1/3 share of this S1, it will be again 4 shares. So son plus 3 sons. So she gets a 1/12 share. This man gets a 1/12 share. This man gets a 1/12 share. And he also gets a 1/12 share. As far as this person is concerned, he has only one son. So this son will get a 1/6 share. This son also will get a 1/6 share. So therefore, in this case, what happens is, these sons get a grandsons get a 1/12 share, whereas this grandson gets a 1/6 share. So therefore, it is, the division is per strips. It is, the division is in respect of this branch gets a 1 share, this branch gets another share. So therefore, branch wise division is called the division per strips. If per capita division is division by heads, so if, see, it's a per capita division, there are how many people? 1, 2, 3, 4, 5, 6, 7 people. We will say 7 people. So if there is per capita division, it is division per head. So everybody should get a 1/7 share. So therefore, per capita and per strips will have got to be clearly kept in mind. Then this tenancy in common and joint tenancy is another principle which one has got to be kept in mind. So if a property should be co-personal property, then it would be a joint tenancy. That is, in joint tenancy, there will be survivorship. In tenancy in common, there is no survivorship. So joint tenancy means unity of 4 things. It is called PIT: possession, interest, title and transfer. All these things are always joint in joint tenancy. Whereas in tenancy in common, their shares are always determined and their shares will not change. Whereas in survivorship or joint tenancy, the shares of each one of the co-partners, it may go up or it may come down. To give a simple illustration, suppose A and B together, A and B together, they purchase one property. Then A has a half share in that property, B has a half share in this property. See, if B dies, then what happens is, this half share will go to his heirs. And if it is joint tenancy, then this share will go by survivorship to A. So therefore, in a tenancy in common, the shares are always determined, and whatever share belongs to them, it goes to their successors by succession. So therefore, the joint property and joint family property is another distinction which we have got to keep in mind. If there are 2 persons in a joint family who earn their property by their joint effort, it is only by their joint effort. They have not made use of the joint family property at all. In such a situation, the property acquired by them jointly without the aid of joint family properties would not be joint family property, and it would be joint property, and they would be tenants in common and not joint tenants in respect of the property. This distinction will have got to be clearly kept in mind. Then Then there is one other area where, in fact, how section 6 as amended in 2005 will have got to be read is explained by a decision of Justice Nariman in year 2016 Supreme Court 1169. That is Uttam versus Subhaksi. In fact, they have put about six points which are as per the decision of the various of the earlier decision of the Supreme Court. And see, I would read this the essence of the decision. In fact, in the operative portion, this is what is reproduced by the Supreme Court. When a male Hindu dies, after the commencement of the Hindu Succession Act 1956, having at the time of his death an interest in Migatakshara Kopasthari property, his interest in the property will devolve by survivorship upon the surviving members of the family. That is the main principle. To proposition 1, an exception is contained in section 30, the explanation of the Act, making it clear that notwithstanding anything contained in the Act, the interest of a male Hindu in Mitakshara Kopasthari property is property that can be disposed of by him by will or testamentary succession. This I have already explained. A second exception is engrafted to proposition 1, is contained in the provisions of section 6, which states that if such a male Hindu had died, leaving behind a female specified in clause 1 of the schedule, or a male relative specified in that clause, who claims to such female relative surviving him, then the interest of the deceased in the Kopasthari property would devolve by testamentary or intestate succession and not by survivorship. In order to determine the share of a Hindu male Kopasthana, who is governed by section 6 proviso, a partition is effected by operation of law immediately before his death, that is notional partition. In this partition, all the Kopasthanas and the male Hindu's widow get a share in joint family properties. On the application of section 8 of the Act, either by reason of death of a male Hindu living self-applied property or by application of section 6 proviso, such property would devolve only by intestacy and not by survivorship. The last clause is what is very important. On a conjoint reading of section 4, 8 and 19 of the Act, after joint family properties has been distributed in accordance with section 8 on the principle of intestacy, the joint family property ceases to be joint family property in the hands of various persons who have succeeded to it, and they hold the property as tenants in common and not as joint tenants. So then the other any break in the middle or anything like that.
So we can continue. People have gone and come back. We want a break or we'll continue and finish it off? We'll continue and finish it off.
How much time can I have?
So 20, 25 minutes.
What's the time?
12:15. 12:40 tak you can.
Now, there is one more point which we should keep in mind. This is how the Supreme Court has interpreted. Let us suppose that there is co-partnership and joint family properties, and a partition is effected by all the members of the co-partnership, and shares are allotted to various members of the family. Then what is the character of the properties
that is allotted to the shares of these persons at a partition by operation of section 90. In fact, prior to 1956, if any person derived right to any property by virtue of a partition, the property in his hands would be joint family and co-custody property. So, but after 1956, because of operation of section 19, if property is allotted to a person at a partition, in his hands, the property will become joint self-acquired property. The property which was initially co-custody property loses the character of co-custody property when once there is a division of the properties by various persons in the joint family. The property in the hands of the various sharers to whom it is allotted, it becomes self-acquired property in their hands. So therefore, the co-custody property loses its character as co-custody property, and nobody will get a right by birth thereafter. Now these properties get converted into self-acquired properties of the persons to whom those properties are allotted. But the first decision in that regard is AIR 2008 Supreme Court, page 2489. That is Haldio Rai versus Shakuntala Devi and others. This is what the Supreme Court has said. When an intention is expressed to partition to co-custody properties, the share of each one of the co-partners becomes clear. When once the share of the co-partner is determined, the property ceases to be co-custody property. This is what is important. The property which was earlier co-custody property ceases to be co-custody properties. In such event, the parties would not possess the property as joint tenants but as tenants in common. When a co-partner takes a definite share in the property, he is the owner of that share. This is what's important. He is the owner of that share, and as such, he can alienate the same by sale, market in the same manner as he can dispose of his separate property. Then another decision of the Supreme Court is 2020 SAR Civil 127 Radhabai versus Ram Narayan. This is another decision. Then there is one more decision, very recent decision of the Supreme Court, which is not yet reported. That is Civil Appeal number 5401/2025. Angadi Chandranna versus Shankar. This is disposed of on 22/4/2005. In fact, in this particular decision, the Supreme Court has explained the law in clear terms when compared to the earlier two decisions of the Supreme Court. In paragraph 19 of the judgment, this this how the Supreme Court has said. See, in the facts of that case, it cannot be disputed. That's what the Supreme Court has said at paragraph 17. It cannot be disputed that the properties divided among defendant number 1 and his children through partition deed dated 9/5/86 are joint family properties. So therefore, it was concluded that the properties were joint family properties and the parties had entered into a partition on 9/5/1956. However, as per Hindu law, after partition, each party gets a separate and distinct share, and this share is what is important, and this share becomes their self-acquired property, and they have absolute rights over it, and they can sell, transfer, or bequeath it as they wish. Accordingly, the property bequeathed through partition becomes self-acquired property of the respective sharers. In fact, this is also made further clear in paragraph 19. As reiterated above, after the joint family properties has been distributed in accordance with law, it ceases to be joint family properties. This is what it ceases to be joint family properties, and the sharers of the respective parties and the shares of the respective parties become their self-acquired properties. Hence, the suit property acquired by defendant number 1 becomes his self-acquired property on being sold by his father Tippeswamy to him by sale deed dated 16/10/1980. So therefore, the Supreme Court has hit the nail on its head in this latest decision, and they have said when once there is a partition, whatever may be the nature of the property partition, whether it is joint family or joint family property, they get converted into separate properties of the sharers, and they can dispose of the same in any manner they want. So therefore, by this, practically the entire concept of a co-parcellary property is completely lost. You see, by applying these principles, there is no co-parcellary property at all. So if a daughter is now given a share as a co-parceller, and if there is no co-parcellary property, what is the benefit a female gets? You will have a share in properties which are not in existence. That's all. So every property is self-acquired property. There is no co-parcellary property at all. A daughter or female gets a share in a property that is never in existence. Therefore, the legislature is only an eyewash for females to say that they are co-parcellers, they will get a right in non-existent properties. That is the total effect of these two series of decisions. Then there is one more thing that will have got to be kept in mind. As far as females are concerned, section 14 is one section which we have to keep in mind always. Prior to 1956, a female had only a right to enjoy these properties. She did not get an absolute estate in these properties. Therefore, section 14 was introduced. By introduction of section 14, what the legislature intended to do was, whoever had a limited estate in these properties, those estate would enlarge into an absolute estate. So if on the day when the act came into force, if a female was in possession of the property and she had a limited estate in the property, that would, by virtue of section 14(1), enlarge itself into a full estate, and she would become the absolute owner of the property. That is section 14(1). In fact, one has got to read section 14(1) more carefully, because this has been the subject of various decisions of the Supreme Court, wherein they have given some benefit to women in respect of the shares that they would be entitled to, in respect to the properties which they have acquired. I will read section 14(1) with little care. Any property is what is important. Any property possessed by a female Hindu, whether acquired before or after the commencement of the act, shall be held by her as full owner thereof and not as a limited owner. So therefore, this is the primary section. This contains an explanation. In this subsection, property includes both movable and immovable property acquired by a female Hindu by inheritance or device. She could have got it by inheritance or device, or at a partition, or in lieu of maintenance, arrears of maintenance, or by gift from any person, whether a relative or not, before or after marriage, or by her own skill or exertion, or by purchase, or by prescription, or in any other manner whatsoever. So therefore, it includes all types of acquisitions, manner whatsoever, and also any such property held by her as Sridhana immediately before the commencement of the act. So therefore, whatever property she had, whether acquired before or after the commencement of the act, would become her absolute property, and she can deal with that property in any manner she wants. Then the section 14(2) says, nothing contained in subsection 1 shall apply to any property acquired by way of a gift under a will or other instrument or under a decree or order of a civil court or under an award where the terms of the gift, will or other instrument or the decree or order or award prescribed a restricted estate in such property. So suppose under a will, a lady is given only a right to enjoy a property during her lifetime, and it is stated that it will belong to somebody else afterwards. So therefore, if or a gift is made in such a fashion, or under a sale deed such a right is given, then she will have only a limited estate in respect of those properties. But in respect of all other properties which she has acquired, as described in section 14(1), the same will be her absolute property. So therefore, the Supreme Court has gone to the extent of saying, if the property is recorded in the name of a female, sufficient, the property belongs to her absolutely. This is what the Supreme Court has said in a few decisions. I would only draw your attention to a few decisions of the Supreme Court in this regard. The first decision is a decision of the Supreme Court reported in 2011 SCR Civil, page 848, 871. This is Gangamma versus G. Nagaratnam. This is a case from the Karnataka High Court. This was a case where a daughter-in-law had filed a suit for partition. One property was acquired in the name of the mother-in-law. The evidence was that the mother-in-law had no income of her own. The father was fairly affluent. He owned a car and all that. Therefore, the Karnataka High Court said, in that view of the matter, we cannot say that the property belonged to the mother-in-law exclusively, and therefore a share was given to the daughter-in-law in this property also, considering this property as belonging to the family. The matter went up before the Supreme Court. This is what the Supreme Court has said. And the High Court found that evidence was adduced to show that the husband of the plaintiff had substantial income and he owned an ambassador car. In view of this evidence, the High Court held that the properties of items 1 and 2 are joint family properties. The learned counsel for the appellant contended that without any evidence, the High Court that may not be relevant. So therefore, the court said it did not go into the question of income at all. It did not go into the question of who gave the money for purchase of this property also. This is what the Supreme Court has said by application of Section 14(1). Section 14(1) of the Hindu Succession Act has a bearing on this issue, as the properties at item number 1 are recorded in the name of the appellant, that is mother-in-law who was the appellant before the case. In the absence of any evidence to the contrary in this case, the appellant, by operation of Section 14(1) of the said Act, is the full owner of those properties. In the facts of this case discussed above, it has to be accepted that those properties are not joint family properties, but the appellant is the sole owner of those properties. The principles laid down in Section 14(1) of the Act have been read by courts in a very comprehensive manner. The said Act overrides the old law of Tridana in respect of properties possessed by a female. So they refer to various decisions, and this is what they ultimately say. In view of such consistent views taken by this court as to the interpretation of Section 14, we hold Section 14. We hold that Section 14(1) of the said Act would apply in respect of properties which stand in the name of the appellant, and the appellant would be the full owner of this property. Then there are other decisions in this regard. In fact, the Karnataka High Court goes a still further. They have said in 2015, 1 Karnataka Law Journal, page 698. In fact, in paragraph 11, this is what the Karnataka High Court has said. Even if it is presumed that the joint family, by investing its funds, has purchased the property in the name of female member of the family, such property becomes absolute property of the female member, and the other members of the family have no right to ask such family members to put the property into the common hodgepodge, seeking partition in respect of the property between the members of the family. This legal aspect has been completely overlooked by both the courts. So even if from the income of the joint family, the property is purchased in the name of the female, it becomes the exclusive property of the female. Then there is one other decision of the Supreme Court, wherein it may also be kept in mind, that is 2011 SCR Civil, page 871, and another decision of the bench decision of the Karnataka High Court in RFA 100238 of 2017, Shivagangava versus Mahadevappa. This is a decision of Justice Govindaraj, where he has clearly said that all properties, even properties that are allotted to a female at a partition, would be as exclusive properties, and if she has sold those properties, his daughters cannot claim a share in these properties. In fact, there is one other Karnataka decision in that regard, which is also which may also be noted. That is 2022 3 KCCR, page 2358. In this decision also the court has said that whatever properties are acquired to the female, irrespective of the fact from where the consideration flowed, the properties would be the exclusive properties of the female, and succession to those properties would be governed by Section 15 of the Hindu Succession Act. Now, there is one area which I did not touch, and that is what are co-partnership properties prior to 1956. See, normally there are 3 or 4 classes of properties which were generally understood to be the co-parcel or joint family properties. One, as I have covered this point, property acquired by inheritance from father, grandfather or great-grandfather. That was prior to 1956. I am making a reference. Property acquired at a partition amongst the members of the family. In fact, these 2 types of properties have now become self-acquired properties. We will leave it at that. Then, property acquired by any member of the joint family with the aid of joint family nucleus and income from joint family properties. One more thing we have got to be kept in mind. In a joint family, the eldest male member is always presumed to be the manager of the family. So therefore, the manager of the family generally gets all the income from the property into his hands. And he may purchase other properties also in his name with the income derived from joint family properties. Then the property so acquired with the aid of joint family nucleus and joint family income would become joint family properties. So therefore, the question is how these things will have got to be established. The burden is always upon the person who claims that a particular property is joint family property to prove the same. That is the normal rule. But if he is able to establish that the family has sufficient nucleus from out of which the property in question could have been acquired. If this nucleus is established, then the burden shifts on the member who has purchased these properties to show that he has not acquired these properties with the aid of joint family income, but has acquired the properties with his own funds. So therefore, in order to prove this, what is it that the plaintiff has got to do? In fact, I give an illustration. Suppose a family has a house, a large house, in which they are living, but it is worth crores of rupees. Merely because the property is worth crores of rupees, because it is not fetching any income, then there is no income from the joint family properties out of which the new asset could have been acquired, therefore that would be of no use. Let us think that the family has 100 acres of agricultural land and they have large number of borewells, grape gardens and other crops are grown. The family gets much more income than what is required for its maintenance. If that is shown, then the burden shifts upon the person who has acquired the property to show that he has not made use of the income. Therefore, the most important thing to be proved is not the number of acres of property which they own. The most important thing to be proved is that the income that the family was getting. That is the most important thing to be proved. In fact, there are a large number of decisions in this regard, and I would like to make reference to only one decision of the Supreme Court in this behalf, where they have looked into the law in great detail. That is here 2003 Supreme Court 3800. It is D.S. Lakshmaya and Mother versus L. Balasubramanian. In this case, what happened was some property was acquired in the name of the male member of the family. The court had come to the conclusion, the High Court had come to the conclusion that because he had no other independent, the person who had acquired the property had no other independent income, this property was also joint family property, and therefore a decree was for partition had been passed. The matter landed up in the Supreme Court. An appeal was filed before the Supreme Court. In fact, the Supreme Court has gone into the question in great detail. They have referred to various other decisions of the Supreme Court also in this regard. A reading of this decision will certainly give you an insight of the law in this regard, and I want every one of you to go through this decision. And they ultimately refer to one more decision of the Supreme Court which has laid down the law. That is Srinivasa Kanungu versus Narayana Kanungu. That's an earlier decision of the Supreme Court. See, that was a case in which in Srinivasa Kanungu versus Narayana Kanungu, in paragraph 10, they make a reference to this decision. In Srinivasa Krishnarao Kanungu versus Narayan Devji Kanungu and others, the contention was urged on behalf of the appellant was that the burden was wrongly cast upon the plaintiff of proving that the acquisition of the property was made with the aid of joint family funds. The argument being that as the family admittedly possessed the ancestral Vatan lands of the extent of 56 acres, it must be presumed that the acquisitions were made with the aid of joint family funds, and therefore the burden lay on the dependents to claim that the property was self-acquired to establish that they were made without the aid of joint family funds. In this case, what happened was, it was proved that the family had 56 acres of land, but still there was no evidence of income. What they said, what is important was, there must be evidence of income, not merely proof of properties. So because there was no evidence of income, in Srinivas Kanungu's case, they came to the conclusion that the property acquired in the name of the male member was his self-acquired property and not joint family property. A similar rule was applied in this case, and therefore the court said that they owned a small extent of the joint family owned a small extent of wetland, and what was the income from this wetland was not available in the case. So if the proof of income is not there, then the plaintiff cannot be held and the property cannot be held to be joint family property. In fact, they have referred to various judgments, and the law on this subject has been clearly dealt with by the Supreme Court, and therefore this is one judgment which would be very helpful to you in this regard. Then the third category is property belonging to an individual co-partner, acquired by him out of his individual income, can be thrown into the common stock. That is called, popularly called as blending. So for proof of blending, specific evidence has got to be given. Merely allowing some other members of the family to use that property is not sufficient. The mental element in the man to whom the property belongs has got to be established by various other factors in the case. So unless this mental element of giving up his right and throwing the property to the common stock is established, then it would not become joint family property. Then one more point which I have already said was a distinction between joint property and joint family property. That may quite clear. In fact, that question has been dealt with by a decision of the Supreme Court reported in 1995, 6 Supreme Court cases, page 523, P. Periswamy versus P. Pirithambi. In fact, what happened was, this was a case where two members of the family they acquired property and in their name, in their joint name. And from the income of that property, they acquired a few more properties. What would be the character of those properties which were purchased out of these joint funds? It is not joint family funds, it is joint funds, because the property which they had purchased was joint property and they enjoyed these properties as tenants in common, and they were entitled to an equal right in the income from these properties. Therefore, the income from these properties was used to purchase another property in their name. Therefore, that it is the joint property of these two joint families, though they may be members of a joint family, it is joint family of these two persons. Therefore, the property acquired with the income of the joint property would not be joint family property, it would be joint property of these two of the person who has acquired the same. In fact, I would like to read a few sentences from this decision. In view of the interpretation put by the full bench of the Madras High Court that the sons in such a situation would get self-acquired property of their father by inheritance, having the status as tenants in common, they could not treat such properties in their hands, even though joint in enjoyment, as joint Hindu family properties. Likewise, the income derived therefrom, if employed to purchase other property, would not cloak the new acquisition with the character of joint family property, but may otherwise be joint properties. If the parties herein were co-sharers, is what is important. If the parties herein were co-sharers of the property, and the said property had been purchased from the income derived from joint property, then obviously the same has to be accounted for as joint property and not as joint family property. From what we have stated above, it is plain that the property in possession of these two branches of the family sought to be partitioned was not joint Hindu family property, because the three sons obtained it by inheritance from their father, the last elder, and their status was that of tenants in common. If the